Thank you to everyone for joining our annual 20F update webinar. I'm Brian Hirshberg, and I'm presenting today along with my Mayor Brown colleagues, Larry Cunningham, and also Tom Kollar. I think those who have joined the last several FPI 20F update webinars are familiar with Larry and myself, and our bios are in the back of the deck if not. But Tom graciously agreed to join us for this one. And so, Tom, if you want to take a moment to introduce yourself and a little bit of your practice for those here in the States that may not be as familiar, that would be great.
Thanks, Brian. Thanks, Lawrence. I'm very happy to be here today. My name is Tom Kollar. I'm a partner in our Hong Kong office. I lead the corporate securities practice for Mayor Brown in Asia. Today, I'm going to be helping Brian and Lawrence on some of the 20F topics and trying to come at it from an international perspective, especially from where I sit here in Asia.
Perfect. Thanks, Tom. This is the agenda we have for today. So we got many topics. I'm going to start us off with the disclosure updates, those that the SEC has been focusing on, given recent rulemaking and comment letters. Larry will cover the new clawback policy requirement. And as Tom mentioned, he'll cover the Holding Foreign Companies Accountability Act. Finally, Larry will address risk factor disclosure updates and areas of SEC focus in the coming months. So with that, let's dive right into the next slide. So mid last year in July, the SEC adopted final rules aimed at standardizing and enhancing the disclosure relating to cybersecurity incidents. So breaches and also the risk management processes that public companies have in place. So these rules require FPIs, foreign private issuers, to report material cybersecurity incidents, breaches on Form S6K, right? And also annually disclose cybersecurity risk management processes, those that they use in a much more standardized manner than had been previously done in 20F filings. So this new disclosure is applicable for calendar year FPIs, so those with December 31, so those that are filing their 20Fs this month and next, and the cybersecurity incident reporting on that 6K that commenced at the middle of December last year. So that is in effect for most FPIs. If you're an FPI that does qualify as a smaller reporting company, you're given an extra 180 days. So you aren't in that compliance period yet, but you will be in mid-June, June 17th of this year. So next slide. So Form 20F now requires disclosures of the processes, if any, for identifying and managing cybersecurity risks, the board's role in the oversight of those risks, and management's role in managing those risks and implementing the cybersecurity policies and procedures of the company. So as a consequence, FPIs need to think about disclosing, number one, whether and how their cybersecurity processes have been integrated into their overall risk management procedure. Number two, whether the company engages third parties, assessors, consultants, auditors, any other third party that would help them with their process. Number three, whether the company has oversight in order to identify material risks from those cybersecurity threats that are associated with the use of a third-party service provider. So FPIs must describe the process by which the board, or if the board has designated to a committee this oversight role, how it is informed of cybersecurity risks and, obviously most important, any breaches. Next slide. So that's what has to be disclosed. What does not have to be disclosed is the frequency with which the board or the committee that's been designated discusses cybersecurity risks. So you don't need to get into, board committee level conversations and the frequency of those. And whether the board considers cybersecurity risks as part of its overall business strategy, how it fits in there, none of that, is required to be disclosed. The SEC added a materiality qualifier requiring FPIs to describe management's role in assessing and managing the company's material risks from those cybersecurity threats. So you have to, understand where your materiality threshold is as it relates to the topic. And then that, essentially triggers disclosure. FPIs need to address management's portion, and again, identify the committees that are responsible for managing the cyber security risk, and identify the relevant expertise. What about their background? What about their skills gives them the ability to manage this on behalf of the company? Why have they been designated to do so, right? Notably for FPIs, the SEC did not amend 20F to require annual updating regarding previously disclosed cybersecurity incidents. This is what was originally proposed by the SEC, but the final rule didn't adopt that. So that's good news. In addition, while many US issuers will now be required to file an 8K disclosing the occurrence of a material cybersecurity incident within 4 business days of the occurrence. So this is filed on 8K very, very quickly. The SEC did not impose a similar mandatory disclosure requirement for FPIs. So that's extremely important. The SEC, however, did amend 6K to add the material cybersecurity incident to the categories of items that should be disclosed in that 6K report. In the SEC's adopting release of these rules, it noted that in order for a material cybersecurity incident to trigger that 6K filing, the usual standard for 6K would apply. So the relevant information would still be made or be required to be made under the public company's home country laws when that home country, or if it's dual listed, the foreign stock exchange would require disclosure or would require distribution to the company's security holders. That would still be a trigger for the 6K. So it's very important that the SEC maintain that traditional approach to disclosures for FPIs. As we'll talk about later in other contexts, they did not provide similar accommodations for other rules that were adopted. Next slide. So turning now to the new annual disclosures relating to 10b5-1 plans and policies. So as background here, in December of 2022, so a little more than a year ago, the SEC amended its insider trading rules and arrangements and related disclosures. So those amendments added conditions to the availability of the affirmative defense to insider trading liability that is currently housed in 10b5-1 under the Exchange Act. So the amendments were designed by the SEC to address concerns regarding the alleged abuse of the 10b5-1 rule by insiders. So there are now these new annual disclosures relating to the insider trading arrangements, and they are applicable in some contexts for the 20F. So narrative disclosure is going to be required concerning a company's option grant policies and the timing of those option grants related to the release of MNPI, or material non-public information. How does the board determine when and whether to grant options? And if it does, or if the board does, or one of its committees, the comp committee or another designated committee decides to give options, how does the company also take into account MNPI when determining the timing of those awards? So item 16J of Form 20F will require foreign private issuers to disclose whether they've adopted insider trading policies and procedures for its directors, officers, and employees. So think about it in the context of option grants, not just the standard 10b5-1 plans. Companies that have adopted them, those policies and procedures related to insider trading, are required to file them as exhibits to their 20F, so they do become public. If a company does not file them because they don't have them, it will be required to disclose in the 20F why it has not done so. So most companies will be filing, and most companies already have, policies and procedures either in accordance with home country or, again, dual listed. The other exchange is requiring that, but those policies and procedures will have to be filed publicly here. Now, a longer transition applies for these 10b5-1 annual disclosures. Companies with a 12/31 fiscal year end do not need to provide them until next year's 20F filing. So companies other than smaller reporting companies with a June 30 fiscal year end will have to do so for this June 30, 2024 period. If you are a smaller reporting company, you get the additional year to June 30, 2025. Notwithstanding the longer transition period here, it's obviously worthwhile to update those insider trading policies now, well in advance, to reflect the amendments, because again, they're going to have to be publicly available. The 10b5-1 amendments also imposed a cooling off period for plans entered into by DNOs. FPIs are going to need to implement new processes to identify who these individuals are. The rules piggybacked off of Section 16, which is, as you know, that's not applicable to foreign private issuers. So that analysis isn't a common one for FPIs to undertake. So it may take more time to identify the executive officers for Section 16 purposes for the 10b5-1 amendments, because that hadn't been done before. So for FPIs, the cooling off period that is now required is the later of 90 days after the adoption of the plan and the earlier of 2 business days after the furnishing of the information on the 6K or the 20F, basically whenever the quarterly earnings, information, financial results come out, or 120 days after the adoption of the plan. FPI should be able to continue to use their existing practices with respect to releasing financial results on 6K, releasing them as part of a furnished, not filed earnings report. That shouldn't really change. Importantly, the SEC chose not to subject FPIs to the new detailed quarterly disclosures that U.S. companies must now provide under 10K and 10Q with respect to any trading plans adopted or terminated by a DNO. Worth also saying too, when I mention FPIs, I'm talking about FPIs that are subject to the 20F 6K regime. You may be an FPI that has voluntarily chosen to subject itself to the 10K, 10Q, 8K regime, in which case those new detailed quarterly disclosures that are applicable to U.S. companies would also be applicable to those FPIs too. Moving on now to the next slide, climate change. So as you may recall, the SEC proposed extensive climate change disclosure rules back in March of 2022. So now almost 2 years ago. The final rules have not been adopted yet, but they did obviously in their proposed form prove quite controversial and generated a significant number of public comments from all sorts of market participants, both foreign and domestic. The SEC is anticipated to likely finalize those rules relatively soon. and they very well, depending upon what form they come in, it would not be surprised if they're subject to a legal challenge or judicial scrutiny, assuming they're adopted as they were proposed. So as of right now, it's not exactly clear what the scope of those final disclosure rules for climate will be or when they'll be effective. But even without this specificity, for this 20F season, the SEC has given guidance in the past on which existing SEC rules already require climate change disclosure. So back in September of 21, the SEC's Division of Corporation Finance, they published a sample comment letter that was given to public companies, and this included climate change disclosures or the absence of disclosures that the SEC saw in SEC filings. So the sample comments that were provided requested analysis, more disclosure to the extent the public company thought material, and that certainly applied to foreign private issuers as well. Of course, there's also been an increased focus amongst the investor community to push companies to voluntarily include more sustainability initiatives in their annual report filings. The approach of adding voluntary climate change and other, frankly, ESG disclosures, provide an opportunity for the company to, control the messaging and provide a basis for shareholder engagement in this area if that is so sought for. But when doing so, companies, FPIs need to be cognizant that the securities laws, there are legal ramifications to these disclosures. And so any, misleading climate change disclosures are very likely going to give rise to an SEC or perhaps a state enforcement proceeding, perhaps significant monetary penalties. So from a liability perspective, it's extremely important and prudent for companies to characterize their corporate climate change initiatives in aspirational terms, right? Rather than as specific commitments to achieve a specific result by a specific time period, right? Unless the company is, actively, well on its way towards reaching that goal within a designated time frame and is prepared to address the inherent follow-up related to that disclosure, it's best to leave the goals in an aspirational type mode. But notwithstanding that, perhaps best given the likelihood that this is coming down the pike for companies to expand what they have been doing. And as part of that, expand their disclosure controls and procedures so those disclosures can be taken into account as the overall drafting of the 20F and the climate change disclosures have a process to essentially fact check them as part of it. They should be consistent with the company's other disclosures in foreign jurisdictions. Europe, as we well know, have rules that have already gone into effect. The company may have sustainability reports that are otherwise made publicly available on the FPI's website, or they publish it in other, third-party providers. All of the public statements in the 20F need to be, conformed and checked with the other public statements that have been already made or required to have been made by laws in other jurisdictions. So it's very important to both be consistent and also characterize it in a way that's not, of course, inaccurate or misleading. So if adopted, the impact here on FPIs would differ from US issuers in a number of respects. FPIs, do have the option of voluntarily disclosing in their home country what those requirements are. So US companies don't, have the ability to do that. but the SEC's proposal, and it'll be interesting to see if it changes, does require certain financial statement metrics to be included in the disclosure of the notes to the financial statements, regardless of whether the FPI uses IFRS or US GAAP. So this is another area where usually there's an accommodation that the SEC defers to IFRS if a company is going down that route. But here, notwithstanding the preparation of IFRS compliant financials, the proposed rules still did require FPIs to prepare financial statements that have additional climate change disclosures in them, which is interesting if that disclosure standard is actually adopted by the SEC. We'll see. Larry, I don't know if you want to kind of comment here on the climate change disclosures. I know you recently testified about these. So I don't know if you perhaps have any more update on what you think the direction here is going, or the climate change disclosures generally.
Thank you, Brian. I'm happy to. I did testify in Congress last month about the proposal, which is controversial and is probably going to be at least tweaked. It would be surprising if the proposal were released or finalized in the same form. As you noted, the SEC received abundant comment letters, 15,000 total. Some of them were form letters, but you count through them, about 2,000 different letters with significant substantive comments. Even the ones that were supportive overall had some questions and doubts, and there were quite a few that challenged it overall on many different levels. So, and that's why that's part of the reason it's been taking so long. They have a lot of work to do to try to address all the comments, something that our administrative law requires the agency to do. So it's taken some time. I predict it'll be considerably different. You're right that it'll nevertheless probably attract litigation to enjoin it or to remove parts. So I think we're still a long way away from having U.S. federal disclosure rules on it. But as you also said, almost every other jurisdiction has something, led by Europe, including California, individual countries, Germany, France, the UK, Brazil, Mexico, Hong Kong, Singapore. And so for the FPIs out there, undoubtedly you'll be balancing disclosure obligations in multiple jurisdictions, which one final point, Brian, is my guess also the SEC's proposal drew heavily on some of the international protocols and will likely try to synchronize as best as possible with what's going on around the world. So it's very much a work in progress with the SEC, but obviously the staff, the agency is, it's a high priority for them, whatever form it finally takes.
Absolutely. So next slide here, Caitlin. This will be the final point on disclosures before I hand over to, and Larry can touch on the clawback bits. But companies are required to discuss their human capital resources. So this includes the number of employees as well as any human capital measures or objectives that the company focuses on as part of managing its business to the extent material. So here, for FPIs, these were updated and expanded significantly as part of last year's 20F. And so it's very worthwhile, I think, for companies in certain industries to take a look at their peer company disclosures, in other industries. What did they expand on last year in their 20F filings or their 10K filings as far as human capital objectives and goals? I think that's worthwhile to kind of take a peek at that, because these requirements here, these are principles-based requirements. So it doesn't specify the type of information. These aren't prescriptive, tailored requirements that are going to identify exactly what is material to a given company. But instead, the regulation identifies measures or objectives that address generalized things such as the development or attraction, retention of personnel. What are disclosures that are particularly relevant for a given company, depends on its business and workforce. So it's worthwhile to look at your peer companies to understand what they have been doing, because there's been a very big wide variation in how companies have implemented these human capital management disclosures in their 20F filings, including with respect to the amount of detail given. So institutional investors, we've heard, have increasingly made this a high priority. So many shareholder proposals that we've seen, many initiatives have requested companies to disclose workforce data by race, by ethnicity, by gender. And so, you'll see if you take a look at a lot of your peer companies, they have charts identifying and breaking down employees by those categories. Human capital management, of course, is not just read by your investors, it's also read by your employees, by your employee relations departments. And so, you kind of have to take into account multiple audiences, multiple points of view that are going to be, reading these disclosures. So, the HR department, amongst others, should be, aware of and have impact in how these human capital management disclosures are drafted. This topic continues to evolve. The SEC is very likely to come out this year as part of its agenda to propose additional amendments here to enhance, to expand further the human capital disclosures. And so I think we're likely going to see this at some point this year. And next year, when we do this presentation, we'll probably have even more prescriptive disclosure requirements and no longer potentially be following as much of a principle-based regime. So we'll see, but best to take the bull by the horns here and expand what one did last year and make sure that it's certainly industry standard and that it's at the top level of disclosure. So when those additional rules come in, there's not as much work to do. So with that, I'll hand it over to Larry to move to clawbacks.
Thanks again, Brian. So we'll go to slide 9. And welcome, Tom. Incidentally, it's wonderful to have you join us here, and to the audience. It's nice to see everybody again. This topic of clawbacks is a continuation and maybe the culmination of a series of laws and regulations going back to the Sarbanes-Oxley Act of 2002 and the Dodd-Frank Act of 2010, which generally discerned the connection between incentive compensation and financial reporting misstatements. And so the thought was to let's surgically require a clawback if an incentive compensation is awarded erroneously. And this update, or this latest culmination of this exercise, is notable. It's an SEC rule that requires stock exchange listing standards to in turn require companies to have specific policies on clawing back erroneously awarded incentive comp. And I think what's most notable about this iteration is how strict the trigger is. It's really a no-fault trigger. Also, the larger category of executives that are covered, and also the broad sweep of restatements that trigger the clawback. So the strict general rule mandates clawbacks in the event of a restatement resulting in an erroneously awarded incentive comp to a covered executive. That's the short version of it. There's no discretion in enforcing this policy, just a few narrow exceptions. There's no reductions for taxes the executive might have paid. No indemnification is permitted, and no fault is required. So this statement, more or less for any even innocent reasons are triggers in this. And moving over to slide 10, I just want to introduce on this slide and the next one some key concepts in this policy formulation. First, who's covered? As I said, it's very broad coverage. In the old days, it would be just the top executive, CEO, CFO, but under this, it's a broad range of executives, all so-called Section 16 executives. The president, certainly principal financial officer, principal accounting officer, business unit vice president, heads of functional units and policy positions. So it's a broad group of covered executives. And in the definition of what's an erroneous award, basically any portion of an incentive pay that would exceed the incentive pay that would have been earned under the financials as restated. Flipping to slide 11, couple of additional concepts. The concept of incentive compensation itself. Let's see if I can get that to advance to slide 11. There you go. It's very broad. So any form of pay, it could be cash, equity, and whether it's deferred or vested, that's granted based on attaining certain financial reporting metrics. Then that concept in turn means measures that are used in the company's applied accounting principles or that are derived from those principles, including stock price and total shareholder return. And the definition of restatement is broad. It's any revised set of financials made due to material noncompliance or with legal or accounting requirements in the original financials. And that includes correction of errors. So it encompasses all forms of restatements that commonly or colloquially are called the big R restatements, as well as the little r restatements. And so it's a much broader, I think, and sterner approach to clawbacks than we've seen since Sarbanes-Oxley started this approach. On the next slide, just a few tips as you adopt your policies. Probably already have. We want to keep these up to date. The exchange rules say that the policy adopted along these lines has to capture all incentive comp paid since October this past quarter. And we offer a couple of considerations in policy design there on the slide to let the policy permit offsets of future compensation to satisfy the clawback requirements, permit the company to suspend further incentive comp during any period of uncertainty about whether a clawback might be required, and require executives to sign an acknowledgement letter about this policy, including language saying that this policy will trump any other agreements the company might have with the executive. And finally, on slide 13, just a couple of technical points on this. You'll have to file your clawback policy that's required by these rules as an exhibit to your Form 20F coming up, and check certain boxes on the cover page of the annual report. I assume that everyone has already adopted this policy. At least New York Stock Exchange companies had to have had this in effect as of the end of the year. And a forward-looking note, if you get into a position where clawback is triggered, additional disclosures about the event and the steps that are taken in accordance with the policy will need to be disclosed at that point. And with that, I'll turn it back to Brian to talk a little more, I guess, about this theme that's been percolating about how the SEC's accommodations for FPIs seems to be receding at least a little bit in at least some areas.
Yeah, it certainly has. You know, it's been an interesting shift away. You know, traditionally the SEC, you know, encouraged foreign issuers to access the U.S. capital markets, and as a little bit of a carrot, you made certain disclosure accommodations. You know, you said that you comply with home country rules that'll work. There are corporate governance requirements that the exchanges have in addition to what the SEC has. And so, a lot of times those don't completely overlap or sync with what, a foreign jurisdiction is doing too. But notwithstanding that kind of traditional historical approach, the SEC's, more recent rulemakings and rules that we'll see come down the pike this year, have a different approach, and that those rules have the effect of diluting accommodations that were previously granted to FPIs. So, several specific examples. The buyback rule that was stayed very recently, just a couple months ago, in connection with that proposed buyback rule, FPIs would have been required to disclose repurchases of securities registered under Section 12 of the Exchange Act within 45 days after the end of a fiscal quarter. I mean, that would have been a disclosure requirement that requires that FPI to put in processes and procedures, controls in order to accommodate that. That would have been, historically an example where one wouldn't have imposed that. Instead, the SEC adopted this new form FSR, without a materiality threshold that would have been required for an FPI to report those buybacks. So, quite a big deal. And, while that rule was stayed, the SEC recently came out with its SPAC rules, in which the staff clearly took a little bit of a different approach, I think in part because that buyback rule was stayed, in order to avoid having a similar, difficulty with some of its more controversial rules that may be subject to legal challenge. They decided to provide guidance or recommendations on what, the SPAC rules there ought to do, instead of memorializing a formal rule. And so while the SPAC context is a different context, if the SEC is adopting that kind of approach, that could have a big impact on FPIs if they are now subject to the guidance or recommendations that the SEC is putting out, notwithstanding, that a formal rule hasn't been adopted. FPIs need to take that into account. The clawback listing requirement to file the policy there, and to designate officers as executive officers for clawback purposes when the FBI is not even subject to Section 16, is again another distinct thing. And there are additional considerations for FPIs, especially if that required recoupment, as Larry mentioned, very well could violate home country law. And how exactly does that inconsistency get resolved? So there's a lot of difficulties there. NASDAQ, with the SEC's blessing, has required there to be a certain number of diverse directors on boards. FPIs have a way of satisfying these board requirements in different ways, but they are now subject to diversity requirements. So and there are annual disclosures related to that. There's glossy annual report filings that FPIs are not exempt from. So the calculus somewhat for the SEC regarding whether U.S. disclosure obligation should be imposed upon FPIs has changed, and to the extent that continues, that's going to have a big impact. So we'll see. Something to kind of keep in mind, though, and to keep in mind as the SEC adopts rules that are primarily geared to U.S. domestic companies. As an FPI, you want to be more familiar with that rulemaking, because that obviously could be coming your way. So with that, next slide. So I'll hand it over to Tom to go through the Holding Foreign Companies Accountability Act. Tom?
Thanks, Brian. In the last several years, we've seen the SEC has been issuing more and more targeted guidance regarding disclosure obligations of companies based in or with the majority of their operations in the PRC. And the guidance addresses an array of disclosure issues, including those related to VIE structures, the reliability of financial reporting, the regulatory environment in China, and corporate governance matters. And very recently, the SEC noted in the context of its rules under the Holding Foreign Companies Accountable Act that it's monitoring, in particular, disclosures by certain China-based companies and is expected to provide additional guidance in due course. So as a part of the filing review process, we've seen in the last year, the SEC has issued a number of comments to China-based companies, asking them to enhance their compliance with disclosure obligations under the federal securities laws. So the new guidance, coupled with the rise of comment letters, show that the SEC continues to believe that the company should provide more prominent, specific, and tailored disclosure about China-specific matters so that investors have the material information they need to make an informed investment and voting decision. There are 3 areas of disclosure focused by the SEC for China-based companies. The first is the Holding Foreign Companies Accountable Act, and we'll look into that next slide. Also, the second point of focus is PRC government involvement. And the third point of focus is the Uyghur Forced Labor Prevention Act. Now, looking at the HFCAA, just a bit of a review here, because this came out in 2020, but we're now seeing it put in place as a disclosure requirement in the annual report 20F and item 16I. And we're seeing China-based companies also provide extensive disclosure in item 3 and also in risk factors addressing specifically some of these HFCAA disclosure requirements. But just as a bit of review, so PRC companies identified by the SEC, and these are known as Commission Identified Issuers or CIIs, they must comply with submission and disclosure requirements under the HFCAA and Commission rules for each year in which they are identified. Now, the required disclosures include, among other matters, the percentage of shares owned by foreign government entities, whether government entities in the foreign jurisdiction have a controlling financial interest with respect to the issuer, identification of all Chinese Communist Party officials who are on the board of the issuer or the operating entity for the issuer, and finally, whether the issuer's articles of incorporation or an equivalent organizing document contain any charter of the Communist Chinese Party. Now, as I'd mentioned, you're going to see the bulk of this disclosure in item 16I, and I just like to emphasize this is only for an annual report. It's not for a registration statement. So this disclosure in particular is, in fact, for item 16I of the annual report. You'll actually see that in the note to item 16I. Next slide, please. Now, in addition to what we saw under the HFCAA, the SEC has some particular interest in the type of control and the amount of control, also known as government involvement of the PRC in any China-based company. So here, what we expect to see is in the 20F is disclosure about material risks related to the role of the government of the PRC in the operations of any China-based company. And this includes any disclosure about the material impacts that the intervention or control by the PRC in the operation of these companies has or may have on their business or the value of securities. Just a reminder, control is defined quite broadly by the US federal securities law. And, obviously we think about maybe economic control or voting control, but let's not forget about the or otherwise right at the end of that definition in the federal securities law. So you have to think about, where the government could exert control as or otherwise. And, that's obviously quite broad. So you just need to pay attention to what that may be and make sure you have your disclosure covering these kinds of events, particularly in the risk factors. Next slide, please. We've also seen a very particular disclosure requirement come out by the SEC in 2021 regarding any involvement with respect to the Uyghur community in China. So this is under the Uyghur Forced Labor Prevention Act. This became law in the US in 2021, as I'd mentioned. and this prohibits the imports of goods from the Xinjiang Uyghur Autonomous Region of the PRC. And what the SEC is looking for here is they really, and they brought this up in recent guidance, and they have been getting it in the past disclosure, so they emphasized it again in 2023, is they were looking for tailored disclosure about any material impacts of the provisions of the UFLPA on the registrant's business. Now, some of these impacts include material compliance risks or supply chain disruptions that companies may face, or if they're relying on counterparties conducting operations in that region. That's it really on the China focused disclosure requirements, and the thing to look for as you prepare your 20Fs this year. Brian, Lawrence, back to you guys.
Next slide,
Thank
Caitlin.
you.
Yeah, Larry, you want to take on the risk factors?
Yeah, thanks, Tom, so much. That's a fascinating report and update. Thank you very much for that. And let's see, we'll flip to, okay, there we are. Update to risk factor disclosures. Most of the framework here remains the same, including the rule that if you have more than 15 pages of risk factors, you need to provide a summary in 1 or 2 pages. And the rules, require you to emphasize specific tailored risks your company faces in its operations around the world. Try to avoid generic boilerplate. There are nevertheless trending topics at any given time. The past couple of years have been supply chain, COVID, climate and cyber, and so on. This year, we expect, and we're starting to see, trending disclosure around inflation and interest rates, and also the war in the Middle East. Just to drill down a little bit, and each of these obviously affects different companies in different ways in different parts of the world. So you can provide some granular disclosure here. Just to take inflation, for example, in the United States, it was running a little wild earlier in 2002 and and it came down. It was at 8 or 9%, and it stabilized in 2023, and now it's quite under control. So that's the picture of the U.S. I guess there's still some inflationary concerns, but it's stabilized. In China, things are pretty much the other way around. The greatest concern tends to be deflation, and that can be a broad global risk. But it's important to emphasize the different conditions in different countries in the United States and China, and for that matter, in many other regions of the world. Inflation is running quite high in Argentina and Turkey, for example, quite low in Italy, Denmark, and the Netherlands. And it obviously affects companies in different ways, and you want to provide some context, whether it's demand for products and services, or investment portfolio, or the cost of goods sold. And a similar story on interest rates. Again, in the United States, they'd risen sharply a couple years ago. 30-year mortgage rates were up above 7%, even got to 8% last year. But these also have stabilized and seem to be holding steady. And that's a similar story in Canada and the United Kingdom. Rates seem more moderate in China and other parts of Asia and Europe. They're very low in Japan and Switzerland, higher in other places, very high in Argentina and Turkey. So try in the risk factors section to highlight that, this global variation in the particular exposure that you face, not only within interest rates, but foreign exchange rate fluctuations, market downturns, and generally global financial market conditions. Also, take care to the extent that the company is managing these macroeconomic effects using hedging instruments, derivative arrangements. It's those sorts of factors are worth including too. Finally, Middle East war, obviously posing different challenges for different companies. It reminds of a year or two ago where we had to start concentrating on the risk factors associated with Russia's invasion of Ukraine. So, and again, the extent to which, or the context of risk factors in this area, will vary with companies. Can relate to limiting sources of supply or markets for products, could affect business continuity, prevent operations in certain jurisdictions. So be granular, be detailed, be focused, try to avoid boilerplate. And again, these sorts of conflicts are often aggregated or congregated under the heading of geopolitical risks, which are also real in these regions and elsewhere around expropriation, renegotiation of contracts with the government. And so that's my update on risk factors. Very, very important subject, obviously quite dynamic and volatile. And Brian, do we want to then just wrap this up? I guess, Brian, we wanted to go back to kind of as a final integration topic, I guess, kind of what to expect the SEC's focus to be in the coming months. In a way, if we could go back to slide 2, some of I think the focus is what we've been discussing. I think especially in that segment, there we go, on areas of focus for SEC comments in anticipating 20Fs. I think these 4 topics would be the ones I also believe the SEC will focus on, particularly in the coming months. These are especially the first, third, and fourth ones: cyber, climate, and human capital. This seems to be the highest priority for this the current commission and the staff. Cyber is obviously a pervasive and intense challenge for businesses and governments, and it's a place where there's an enormous amount of focus and care in the creation of disclosure, particularly in your 6Ks. If incidents occur, you're taking care to provide the required disclosure without compromising the integrity of an investigation or of the systems or people's privacy. And I think the SEC's rules on this were sensitive to that balance, but it's going to be a continued area of focus. And as Brian's explained at length, on climate change, the politics of that, the breadth of the SEC's initial proposal, and the inordinate commentary that it attracted will keep that on the front burner for the SEC, whatever it does. And also, as Brian said, on human capital, we've had a principles-based approach to this that I think the staff and the commission is leaning towards a much more rules-based approach. And so I expect the agency to lean in on that and monitor what's being disclosed and use the disclosure and the process to anticipate what their rules or proposed rules ought to look like. So I think those are the likely areas of focus. But obviously, depending on your situation and the company you're with, the 10b5-1 might be of interest. The planning around that, the clawback rulings, and the dynamics of the HFCAA. So all these, I think, are potential areas of focus. We've tried to narrow this presentation down, although obviously the SEC is busy. It's a busy time for their rule production. The staff is busy on the enforcement side, corporate finance division on the disclosure side. So keeping all of us very busy. But I think within that broad milieu, these are probably they seem to me at least to be the highest priorities.
Yeah, Larry, that makes sense. I mean, I think, a couple notes. I mean, I think on the risk factor disclosures, it is worth, reminding FPIs you've got to have a summarized risk factor, section 2. So, any of those interest rate risks, those, geopolitical risks, all that, you need to think about getting those up front in the 20F as part of the summarized risk factors. So definitely consider that. And then, in terms of, where the SEC is going, I think it's, worth saying, I mean, the commission as a whole has been adopting rules for several years now on a more partisan basis. There have probably been more 3-2 votes, and this isn't one way or the other. It's both ways. The principle-based disclosure requirements that we were talking today, a lot of them were adopted under the Clayton, SEC. A lot of the more prescriptive ones we've seen adopted over the last few years. And so we obviously have an election, coming up here, so, determining where the SEC is going to go, unfortunately depends upon, how that election, turns itself out and who exactly is comprising those 3 seats at the SEC. Larry, I don't know if you disagree or not, but I mean, the collaborative nature of that, agency is less than it had been historically. And I think as a result, you see, back and forths in a lot of things. A lot of, foreign companies are doing, private placements. And so they rely on the accredited investor, rule. That definition, was revised under the Clinton regime. And then now under the Gensler regime, you look to revise that definition back the other way. And so I think we're going to see a little bit of that, unfortunately, kind of depending upon who, wins elections and how that goes, because it's been more 3-2 votes adopting rules than I think it ever had been in the past.
I agree with all that, Brian. And just an additional observation, another phenomenon I think we've seen at the agency in the past few years, which it's hard to predict its future, but there is a greater proportion of the senior staff come from academia rather than from practice. The historical leadership has tended to be general counsels of companies, including international companies, and senior securities partners at law firms. And so they had a lot of direct experience with the challenges of disclosure and compliance, and a very pragmatic sense. In the past several years, academics have been more likely to take these leading positions. I spent a lot of my career in academia, and it's a different sensibility. It's more intellectualized, it's more abstract. Sometimes it can be more idealistic than practical. And I think some of the rulemaking and some of the output, some of what in practice lawyers need to deal with is showing a little bit of that. And it's not a criticism. It's just I think a slightly different philosophical viewpoint or texture to some of the rules. And it is more rule based rather than principles based. And there's some, I think, propensity to feel that we're trying to solve problems, and there's a very technocratic solution to them. So it's just, I think, a slightly different jurisprudential view, if you like, or theory of regulation. And you see it in the current rulemaking processes. It's hard to predict whether that would continue in a different administration, but there are certainly going to be some legacy effects of that will continue to manifest, and we'll have to deal with.
That's right. So I think we're at the top of the hour here. Really want to thank Larry and Tom especially Tom, taking the time to join us from the Hong Kong office. We have additional resources at the end of the presentation here, and obviously feel free to contact any one of us if we can be helpful on these disclosure issues or transactional based questions. We are generally available. Thanks everyone for taking the time. Appreciate it.